Thank you very much, and firstly I'd just like to say thank you to Peeroo Chambers, Jamsheed, to the South African Chamber, Richard, and Mark for having me here today. And it is a great pleasure to be here and to be able to discuss an issue which is a great passion of mine, which is arbitration. And of course, it's always against the background of foreign investments and disputes. So the broad topic is South African foreign direct investment in Mauritius, but more particularly the extent of the investments, the broad types, and the expectations, most importantly, of South African investors here when it comes to dispute resolution, arbitrations, and the like. And the message I would like to leave with you today is resolving disputes before they happen, or putting a mechanism in place before they happen, is all about mitigating risk. It's risk mitigation, and that risk is enormous. Richard alluded to it. Litigation can take years and years. I've been involved in a matter which is in its 11th year, with huge discovery issues, interlocutory issues, and the merits haven't even begun yet. It's cost the clients an absolute fortune. We've tried to settle. The settlement has been impossible. And those are the risks, particularly in the cross-border sense, foreign investments, that you should try to avoid. And I'll also talk very briefly about the MARC Centre, its administration of arbitrations, and the MARC Court. So there's no denying that Mauritius is perceived by South Africans as a very attractive investment destination. It's against the back of a declining economy, political turmoil, corruption in South Africa. South Africans are looking for places to get their money out. It's a sad state of affairs, but a very positive one and a very positive opportunity for Mauritius. The South African Chamber here, under the stewardship of Richard Robinson and his executive committee, assists South Africans in developing relationships with Mauritius, commercial relationships in Mauritius, and representing them on various aspects. And it's all about promoting trade and industry in Mauritius from a South African perspective. Just looking at their list of corporate members, there are over 120, if I'm not mistaken. You know, the usual heavyweights are there. There's Investec, Standard Bank, Metropolitan Health, Vodacom, Engen, and a host of other notable South African corporates, and a notable number too of individual members as well. There is a vast amount of South African private wealth flowing into Mauritius against the background, as I say, of a beleaguered South Africa. And a lot of that money winds up in residential estates. I think the most common areas of investment here are residential estates, holding companies, and that's certainly from my firm's perspective of what investments are. Just some statistics, which I get from the report, the annual report of the South African Chamber. Foreign direct investment from South Africa last year amounted to some 1.9 billion rupees, about $55 million, out of a total investment of 13.6 billion. And the South African component represents about 14% of all foreign investment in Mauritius last year. That figure is down from previous years, and in fact quite significantly so from a number of years back. And that is, I think, attributable to the fact that many of the residential estates are now complete. There was an initial burst of investment when these things were being built. The total value of trade between Mauritius and South Africa last year was about 18 billion rupees, which is about $500 million US. And as I say, real estate and financial services were the most attractive sectors. From my firm's perspective, speaking to my commercial partners, there has been some concern about Mauritius from a regulatory perspective. It is sometimes perceived by them as being weak in some respects. I think the Belvedere Ponzi scheme didn't do much to promote that. But on the whole, Mauritius is seen as a very, very attractive investment destination for South Africans. And now to the central theme of the talk, which is disputes. And wherever you get large-scale investment, disputes are bound to follow. And that is where the lawyers come in. We are the grudge purchasers, we are the lawnmowers of the world, the tires. It's a costly, expensive, and unpleasant affair. And I've been involved in litigation for about 30 years or so, particularly with cross-border disputes on a range of subjects. And I can safely say that attempting to resolve these disputes can be enormously costly. You know, it runs into tens of millions of rands, often, and sometimes hundreds, if litigation goes on for too long. It's time-consuming. Executive time is something that you can't really account for. You can't put a value to it, but it costs the company in that aspect. Two, it can take years, and it can also be downright dangerous. I have an anecdote, a case I was involved in the DRC, which gives some examples of just how costly, lengthy, and dangerous it can be. And this is about 8 years ago, so I represented a Canadian mining company in a dispute with a company in the DRC, in which the DRC government held a substantial stake. And we were instructed to attach a consignment of minerals on board ship in Cape Town. And the Cape Town High Court was seized with the question of who owned the minerals, my client, the company, or the DRC company. Now, we had obtained information about the minerals and the ship's due docking date in Cape Town from a colleague of mine in Kinshasa, who had provided an affidavit with these facts, which enabled us to attach the minerals. So this attachment application was pending before the Cape Town High Court, and a preliminary battle ensued for some 15 months on which court had jurisdiction to determine ownership. Was it the Cape Town High Court, or, God forbid, the Kinshasa Court, where it really was a kangaroo court? And eventually, 15 months later, it was decided by the South African court, the Cape Town court, that in fact, was the court that had jurisdiction. And you can imagine, the minerals were tied up, the costs involved were enormous, and the length of time. And then the interesting part of the story was that when evidence was due to be given in Cape Town, we needed my colleague from Kinshasa to give evidence in the Cape Town High Court. And I tried to contact him, but to no avail. It was as if he had dropped off the face of the earth. And what had transpired was that he had been arrested and detained for some 12 months on a charge of high treason without trial. And I remember him telling me that every Friday morning, prisoners under the same charge in the same prison were taken out into the courtyard in front of his cell and shot. And eventually, he was released on humanitarian grounds. A whole number of international humanitarian organizations got involved. And then, stupidly but very bravely, he then agreed to come and give evidence in the Cape Town High Court. It gets worse in some instances. We needed expert evidence on DRC law. An eminent professor from the Kinshasa University was due to fly out, and he was detained at Kinshasa airport. He was roughed up and sent back home, and he couldn't give evidence. And the most sinister aspect of all, and there's some uncertainty as to whether it was linked to the case or not, but some months after we won the case, 4 years later or so, 2 witnesses who had given evidence in the Cape Town High Court against the DRC were found dead in a burnt-out car in Lyon, in France. It's an extreme example, but I tell it because it highlights the risks of litigating in certain parts of Africa. Now, of course, litigating in Mauritius is not even remotely as dangerous as the example I've given. But foreign litigating parties can experience, as I say, incredible delays on preliminary issues before you even enter into the merits. And that's jurisdiction. Often get involved in disputes about which law applies, particularly in a cross-border aspect, and sometimes 3 or 4 parties from 3 or 4 different countries are involved, and they don't choose a law to govern their dispute in the contract, and you can be mired in litigation about that aspect for months, if not years. So it's all about, as I say, mitigating risk, mitigating the risk that accompanies cross-border and most disputes. The general trend worldwide is towards arbitration. Certainly in the Western world, there are many examples of harmonization of arbitration laws. There's the UNCITRAL, which is the United Nations Commission on International Trade law. They have a model law, which a number of states around the world, and 11 of them in Africa, have adopted as their international arbitration legislation. There's also the example of OHADA, which is a treaty. 17 African states are party to it, mainly Francophone, and that treaty deals with the harmonization of business laws in those states and arbitration laws. So there's a uniform arbitration laws amongst all those aspects. I've mentioned UNCITRAL and the model law, and more about that later. That's a very, very important aspect. And now, turning to South Africans investing here, they obviously will bring with them to Mauritius the South African experience and the expectations that they will have in trying to resolve or confronting disputes in Mauritius. And so a little bit about the South African arbitral landscape. I'm not going to speak to you in a very technical way. It's just some interesting anecdotal stuff about what it's all about. And perhaps the most important thing to understand about arbitration is that it's purely consensual. Nothing will ever be imposed upon you without your will. Very much unlike courts, where you are bound, whether you like it or not, by the rules of procedure of the court, the laws of those courts, and customs of those courts, and practice of those courts, and the time scales prescribed by the court or by the rules. So this consensual aspect is what we call in law a technical party autonomy. Party autonomy is very important. It's the freedom of the parties to choose contractually the method in which, the way in which they will resolve their disputes. So any investor here considering a contract on any aspect will give some thought to how a dispute resolution clause will look. And the question you ask is, do I opt for arbitration, or do I submit to the courts of the host country? And we say, well, as an arbitrator, arbitration practitioner, arbitration, there's no contest at all. And the second question, which really flows from that, is to what extent will the host country's courts respect the arbitral process? Will they support it, or will they interfere? And South Africa's history is quite an interesting one, because there's a tension between an aging domestic arbitration act. We don't have an international arbitration act yet. A domestic arbitration act, and that simply means laws designed to resolve disputes between two domestic parties, as opposed to a case where one party might be foreign. And the whole set of different laws apply. So international arbitrations are dealt with under our domestic law and domestic statute, which is a very archaic piece of legislation. It allows the parties to an arbitration to go to court on many issues. So that puts a brake on the arbitral process, and you are then mired in months and months of litigation on some aspects. There's one aspect of our Arbitration Act which says that the court can determine any issue of law arising in an arbitration So if you're a dilatory defendant, you can imagine what a field day you could have by delaying the whole arbitral process. It's very undesirable. So that's on the one hand. On the other hand, you have a judiciary that is coming out very strongly in support of arbitration. And they will keep their interference to an absolute minimum. And it's an interesting tension. The background to the court's approach is a case we were involved in 2007, which really was a watershed year. And it was a massive international arbitration with an American communications company and our South African telecommunications company, Telkom. And what had happened there, we'd appointed an arbitrator, an eminent English QC, who had determined an issue of South African law so wrongly, so incorrectly, and had misconstrued a contract so badly that we said it constituted what is called in arbitration law a gross irregularity. And the Act, the Arbitration Act, says the court has the power in the event of a gross irregularity to set aside an arbitration award. So we took him to court, we took him on review, and the court of the first instance agreed with us. He said, if you've got it so wrong, it is a gross irregularity, we set this award aside. And so confident was the judge in his finding that he refused to give leave to appeal. The other side, I acted for the winning party there. The other side, the American company, appealed to the Supreme Court of Appeal, and we lost. And the Supreme Court of Appeal, 5 very eminent judges, came down very heavily on us. And they said, it doesn't matter. Party autonomy is about the choice. You chose, together with your opponent, this arbitrator to resolve this dispute. If he gets it wrong in law, tough luck. That is a consequence of party autonomy, which the courts must respect. The courts will only become involved if there is an issue with the procedural aspects of an arbitration. For example, if the arbitrator was irregularly appointed, or if he refused to allow a party to give evidence, if he didn't hear the other side of those fundamental issues. So, against this background, and a constitutional court judgment which held that Section 34 of our Constitution gives everyone the right to a fair public hearing, which means everyone has the right to go to court. And of course, people have tried to use that as a means of evading or avoiding an arbitration process, again to delay. And the Constitutional Court has held that that section, that right, does not apply to private arbitration, which is a very interesting development indeed. So, arbitration agreements are sacrosanct. In South Africa, the courts uphold them, they keep their interference to a minimum. We're hoping soon that the Domestic Arbitration Act, with all its opportunities to go to court, will be repealed and replaced. But to sum up, the Constitutional Court's attitude to arbitration, which really sets out the advantages of arbitration, very well, I'll read you this short passage. The Chief Justice said, some of the advantages of arbitration lie in its flexibility, as parties can determine the process to be followed by arbitrators, including the manner in which evidence will be received, the exchange of pleadings and the like. Its cost effectiveness, its privacy and its speed, particularly as often no appeal lies from an arbitrator's award, or lies only in an accelerated form. And in determining the proper constitutional approach to private arbitration, we need to bear in mind that litigation before ordinary courts can be a rigid, costly and time-consuming process, and that it is not inconsistent with our constitutional values to permit parties to seek a quicker and cheaper mechanism for the resolution of disputes. Couldn't have put it better myself in the case of arbitration. And arbitration is particularly relevant and appropriate for cross-border disputes, because what you do, you avoid disputes on which rules will apply, which arbitrator will be appointed, jurisdictional issues which law will apply, and what have you, and avoids considerable delay as evidenced by the DRC example. Of course, arbitration is also recommended highly for domestic disputes between two parties, two domestic local parties. And again, I come back, it's all about mitigating risk. You have to agree all of this in advance. And of course, one of the great advantages of arbitration is that most Western jurisdictions and many states in Africa, I think 34 out of 54 African states are party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And that simply means, and South Africa and Mauritius are party to this convention, and what it simply means is that each country will readily enforce arbitral awards emanating from the other. And enforcement of an arbitrator's award can only be defended or opposed on very, very limited grounds. But the principle is to uphold them, to enforce them, and to give effect to them. The most obvious advantages, and there are some disadvantages too to arbitration, are the following. Neutrality, and particularly in the case of a cross-border issue, foreign parties always have this innate fear that the court of the other party will be biased towards its own nationals. And to alleviate this fear, the best solution is to agree to an institutional arbitration, which Njana spoke about earlier on, because the whole appointment of the arbitrator process will be done by the institution, which will avoid, they will obviously avoid appointing a national from either country if they can, and the whole issue of neutrality is guarded. Flexibility. And this is, again, a great advantage because the parties are free to choose. Come back to the concept of party autonomy, choice, consensual aspects. They choose the venue, the arbitrator, the rules and procedures which will govern the arbitral process, the dates and times. That's very important. The court will say, here's your date, 18 months hence, and you wait, and take it or leave it. Everything is flexible in arbitrations. You agree the date when everyone's available. If a party gets difficult in the arbitral process about dates, then that issue can be put to the arbitrator or to the court, and then a date will be fixed. But on the whole, these are consensual issues which are agreed. Cost. Cost is a big issue. There's a widely held perception that arbitrations are cheaper than conventional litigation. And that, unfortunately, is not always the case. And John has spoke about ad hoc arbitrations, and that's where the parties themselves govern the procedure, choose the rules. There's no institution administering it. Do tend to take longer and cost more because time is money. In arbitrations, you do pay for the arbitrator, you pay for the venue, you pay for the transcription services. In court, all these come free. It's a state cost, a state expense. Now, the cost factor can be ameliorated to a very large extent, and arbitrations can be a lot cheaper than conventional litigation if they are administered properly. And that's where an institution such as MARC comes into play, because the rules, the whole ethos behind the rules and MARC's philosophy is to ensure that disputes are resolved as quickly as they possibly can be. So while there is an administration fee to pay, which is according to a sliding scale against how much the claim in dispute is, can be a huge cost-saving device in the end. And that's about the best advice one could possibly give you. Enforceability, again, I mentioned the New York Convention. Arbitration awards are readily enforced, particularly by countries which are party to the New York Convention. And just to give you some idea of its reach and its ambit, Angola has just acceded to the New York Convention. The DRC, and these are often perceived as renegade states, even they are now acceding to this convention on enforceability. And those are very, very important, important aspects when it comes to arbitration. So, you negotiating your contract, you're deciding what dispute resolution mechanism will be involved. And the first question is, do we choose an ad hoc arbitration or do we choose an institutional arbitration? The disadvantages about an ad hoc arbitration I mentioned before is that it can take longer. The parties themselves choose the arbitrator, the rules to apply, the law to apply, and all of those things. And of course, if you don't agree any of those aspects, then the court becomes involved, and then that leads to considerable delay. Whereas an institutional arbitration, once you agree to an institutional arbitration, automatically the rules kick in, and all of those are resolved. And of course, the rules kick in by agreement. By agreeing to the institution, you automatically agree to its rules, and the whole consensual issue is taken care of. So now a bit about MARC and the MARC Court. MARC was established in 1996. It has a long and proud history, as Anjana mentioned to you. It is importantly independently funded. It is self-funding. It's independent of government, and it caters for the business needs of the community and the society. It is absolutely conscious of what these business requirements and needs are, which again is to resolve disputes as quickly and cost effectively as possible. And it involves and employs best practices, best arbitral practices from around the world. The MARC Court comprises various members. I happen to be a member from various parts of the world, and I'll come to that now. So I mentioned about MARC itself and its rules. So once you choose a institutional arbitration to resolve your disputes, the rules automatically kick in. And how you do this is by a very, very simple clause in your contract, and I'll read it to you. It's a few lines. Any dispute arising in connection with this agreement shall be finally settled under the arbitration rules of the Arbitration and Mediation Centre of the Mauritian Chamber of Commerce and Industry by 1 or 3, it depends, you choose, arbitrators appointed in accordance with the rules. Those few simple words can save an enormous amount of time, effort, and expense. It really is as simple as that. So you're automatically bound by the rules. The primary aim is to ensure expedition, speed, cost effectiveness, and the like. The rules of MARC are very simple and straightforward. They establish the permanent secretariat, which is charged with the administration of the arbitral process. They also deal with the finances of the institution and other related aspects. Now, the process is very simply commenced. Clauses in the agreement. Nothing prevents parties from agreeing to arbitrate after the dispute has arisen, and in the absence of an arbitration clause, the parties often do that. But of course, if the other party doesn't agree, you cannot arbitrate, and the default position is court. Where you've got the clause in there, dispute arises, one of the parties, the aggrieved party, will then refer the dispute to MARC. You give the very basic details, who the parties are, your own details, and what the dispute is all about. It's called a statement of claim. That information is then referred to the respondent, who then has a chance to defend itself and raise any counterclaims. And this is all within a very structured, very strict time period. There is importantly a provision that if a party fails to perform on time or fails to participate, then the arbitration tribunal can proceed in the absence of that party. And that's very important. You can get an award by default, which ultimately will be recognized by a court. So they're very strict about that. And that is an incentive, of course, for a party to participate. The process ends, it's like court, but more informal. The arbitration is held, evidence is led, and then the arbitrator finishes the process by delivering what we call the award. It has to be fully reasoned, like the judgment, it's no different there. And as far as arbitrators are concerned, there are rules for the ethics and the conduct of arbitrators, which strictly prescribe, for example, if an arbitrator appointed has a conflict of interest. He might have a shareholding in one of the parties. He has to declare that up front. And if he doesn't, there are all sorts of strictures which can apply. So turning now to the MARC court itself, it is presided over by Neil Kaplan QC, who is regarded as one of the world's most eminent arbitrators. He really is a very, very prominent figure on the international arbitral stage. It's not a court in the conventional sense. It really is there to work closely with the Permanent Secretariat, and as Njana mentioned, it deals with issues regarding whether MARC should accept the case, in other words, whether there is a binding clause or not, the appointment or removal of arbitrators, and what it does as well, it considers awards before they are presented, and it checks to see whether there are any inconsistencies. It doesn't sit there as an appeal tribunal at all. It just says, for example, if an arbitral award is badly reasoned, the result is this, but you read the reasoning and you can't get there logically. That is pointed out to the arbitrator, and it goes back to the arbitrator, who checks it and fixes whatever issue there is. So when an award is given, it is properly reasoned. And that's very important, because ultimately you want to enforce that award, and you may have to do so in a court of law, and you don't want to give the other side any opportunity to oppose. So, in conclusion, does arbitration in Mauritius live up to the expectations of South African investors? I think it does admirably. Jamsheed will talk shortly about the Mauritian arbitral landscape, but Mauritius adopted into its domestic legislation the UNCITRAL model law on international arbitration in 2008. And so that is quite a while ago. South Africa has yet to do so. It will pass an International Arbitration Act imminently, but we are very behind in that aspect. MARC is well established, has a long and proud history, as we've spoken about, and it's eminently suited to administering arbitrations to a logical, speedy, and expeditious end. Conventional litigation is an anachronism. It simply doesn't fit in the modern business age. It moves too slowly. Business moves incredibly quickly. It is inherently risky. It's costly. And the best way to mitigate that risk is to choose in your contracts, when you invest here, when you transact here, or anywhere, a simple, straightforward institutional arbitration clause which will achieve all those objectives. Thank you very much.